For those of you who are on the webinar, I want to thank you for joining us today. My name is Denny Brennan. I'm the Executive Director of the Massachusetts Health Data Consortium, and I want to welcome you to today's webinar hosted by Adam Green from Davis Wright Tramaine, discussing the operational and cultural challenges of the information blocking rule. Just a few words of order for the webinar. We have over 100 registrants. We're approaching 50 folks online now. So I would encourage folks, if you have a question, to type it into the chat box. And we will pick those questions up as we move through the presentation. If you have questions that you think might be covered in subsequent material, feel free to wait or type your question in any way, and we can let you know. On the landing page, you see it on the screen in front of you. We have both Twitter handles and addresses for Adam, as well as for the presentation today, and any other hashtags that might be of use to you if you choose to tweet from this event. Lastly, we are starting these webinars and have been hosting them all year and throughout last year, and we expect that the Health Data Consortium to produce approximately 30 of these webinars over the course of 2021. We cover a range of issues from policy to information privacy and security, as we're discussing today, interoperability, social determinants of health and health equity and inclusion, among others, but all with a bent toward information and maybe a little less of a bent toward technology, but definitely a bent toward information. We encourage your participation. We encourage your inquiring as to joining the consortium. We have a lot to offer to a lot of folks. Allow me to now introduce Adam Green. Adam is a veteran health law attorney with Davis Wright Tramaine and a former key regulator at the U.S. Department of Health and Human Services. Before joining DWT, Adam worked on HIPAA and the HITECH Act at the U.S. Department of Health and Human Services in its Office of the General Counsel and Office for Civil Rights. He drafted and negotiated the first HIPAA financial settlement agreements on behalf of the government and assisted with implementing the HITECH Act and drafting the first HIPAA breach notification rule. He also advised the department on applying HIPAA to a variety of technologies such as texting, cloud computing, and national health information exchange. Today, Adam's practice focuses on health information privacy and security laws, using his experience as a former regulator to help clients understand how they can permissibly leverage their health data, bring their information security programs into compliance with the HIPAA security rule, and respond to potential breach incidents. He works with healthcare providers, health plans, cloud services providers, health IT companies, and financial institutions who need to navigate HIPAA and the patchwork of other federal and state health information laws. So with that, Adam, I want to welcome you to MHDC and to our webinar today and allow you to take it from here.
Thank you, Denny. Good afternoon and good morning, everyone, depending on where you're located. So thank you for joining us today and for having me. So let me share my screen for a moment. I'll go through the initial lawyerly disclaimers. So I'm looking forward to providing, over the next 2 hours, educational guidance, answering your questions, but what I say should not be taken as legal advice, which I know is just the biggest cop-out. I mean, if your plumber ever showed up and said, yeah, I'm here, but I'm not, don't actually take what I say as plumbing, you'd probably not even let them through the door. But this just means essentially that saying Adam told me it was okay is not actually a legal defense if push comes to shove. I'll also, do the 2020, 2021 disclaimer, dogs barking in the background, possibly a cockatiel squawking, all standard for the course. So, apologies ahead of time. So let me go ahead and go through the agenda a bit. So we're going to start off with why is this important? Why do we care about information blocking? And then a little bit about how we got here, because it's a strange place, admittedly, and a little bit of background there I think can help. We'll talk a bit, some big picture. There's actually not just one information blocking requirement, there's multiple ones. And so understanding how they fit together is helpful. And then we'll really move into some of the key concepts of the 21st Century Cures Act information blocking rule. We'll walk through the exceptions. We'll talk a bit about how to tackle information blocking and then conclude with some takeaways. Now, feel free, as Denny mentioned, to ask questions throughout. I am hoping to be interrupted with questions from the chat to keep this as an interactive dialogue as much as possible. So, why is this important? Just imagine, if you will, that you are, say, a doctor's office or a hospital, maybe a mid-level employee at one of these, and you receive this email. Hi, I'm conducting a quality assessment study for the King's Hospital. Attached is a list of all 2021 admissions to the King's Hospital, including patient names, dates of birth, and discharge dates. Please match this to your patient list and provide me with assessment, clinical notes, and procedure information for each encounter within 90 days of our discharge dates. Call me if you have any questions. Thank you for your assistance. So you receive this email, you receive this unsolicited list of admissions information, and you press delete after you finish laughing at the idea that you're going to just hand all that information over to your competitor across the street. Then you get the follow-up. Hey, I'm just following up on the below email. So you click delete again and move on to your day. What you don't realize is that at this time or shortly afterwards, the sender of the email goes onto the HHS website and starts filling out a reporting form reporting that you are information blocking because he's trying and not getting a response from you guys. So any action or even an inaction, as in this case, that knowingly interferes with access, exchange, or use of electronic health information, EHI, may lead to various disincentives or penalties. So in this case, ignoring that request could represent information blocking. That could is a key term there. I'm not saying that it is absolutely positively information blocking. We'll get to kind of the analysis in a bit. But this could lead to, quote, disincentives. We don't know what those disincentives are yet. There's still a lot unknown with respect to information blocking, but if you're a healthcare provider, as in this use case, this could lead to some sort of disincentives for information blocking. And it could also lead to a decrease in Medicare reimbursement if the recipient, in this case, seemingly surprisingly, attests that, yes, we are information blocking. And as part of the meaningful use program, if they attest to that, they're going to get dinged on their reimbursement. And they'll also get identified on a CMS website as attesting to information blocking. If, on the other hand, they don't attest that they're information blocking, they could be subject to False Claims Act liability for inaccurately attesting to meaningful use. So we've got these mysterious disincentives that remain to be seen, and we've got potential impact on Medicare reimbursement, and even just for good measure, False Claims Act liability. So on top of that, I use this use case for kind of a small physician practice. But if you're a hospital and you're also offering, for example, Epic Community Connect, where you are offering your EHR to independent physician practices in your community, then on top of this, you may also qualify as a health IT developer of certified health information technology or a health information exchange, and you'd be subject to penalties of potentially $1 million under information blocking with respect to if you're withholding information of those physician practices. So sometimes I've done this slides for physician practices where I use that use case. Sometimes I've done it for hospitals where they also request a where the requester also asks information about the physician practices that are being hosted by that hospital. So how did we actually get here? Well, not too long ago, as I'm sure we all can remember, the world was just silos of paper medical records. You go to your hospital, you go to your physician practice, and it might be just charts on a bookshelf, if you will. And then the federal government invested billions of dollars when we were in our last recession, 2008 or so. In response to that and the stimulus in 2009, invested billions of dollars on electronic medical records. Get everyone off those paper records over to electronic medical records. And it had this vision of what I sometimes heard called a learning healthcare system, where information is going to flow. You're going to have better treatment. You get to see, I won't get multiple diagnostic tests that are duplicative. Research could, suddenly go leaps and bounds beyond what it could before based on access to information at a potentially national level. All these ideas. And instead, what did we get? We got PHI, protected health information, trapped now in electronic silos instead of paper silos. And President Biden, forget if it was back when he was vice president, I think he was still vice president when he said this, but I saw a quote of his where he talked about that they really underestimated the market forces and really never imagined that in putting forth the stimulus that they were just going to end up with these electronic silos instead. So really, what kind of market forces did they underestimate? They underestimated the EHR providers, not necessarily having market incentives to make it easy to share between different platforms, but instead kind of the Apple versus Microsoft, create your own little ecosystem incentive. So they underestimated EHR vendors and other health IT developers having potentially incentives to not make information interoperable. And then they underestimated, I think, at the healthcare provider level, that there are not big healthcare incentives for healthcare providers to necessarily share their information, especially if it might be with a competitor across the street. And so, we end up with these electronic silos, and it was recognized pretty quickly. And so the term information blocking was essentially coined. And it made its way into a formal report from ONC, the Office of the National Coordinator for Health Information Technology, to Congress in April 2015, where they identified the issue of information blocking. But Congress already had this on their radar. And so that same month, the MACRA legislation with respect to Medicare actually added an information blocking prohibition to the meaningful use program. So not anything quite like what we're going to see in a little bit on 21st Century Cures Act, but rather provides for the meaningful use to address information blocking. And so over a year later, November 2016, pursuant to MACRA, we had regs that added information blocking attestations to the Medicare, Medicaid EHR incentive program, AKA meaningful use, AKA promoting interoperability program as part of MIPS, AKA whatever they're calling it these days, since it seems to always be changing. But that program, essentially, we had regulations putting information blocking into that program. Then a month later, we had the 21st Century Cures Act come out, and that included an information blocking prohibition. And as we'll see in a little bit, an extremely broad information blocking prohibition, essentially stating that if you're one of the actors that we'll discuss in a little while, there is a presumption that anything that you do that kind of interferes with access, exchange, or use is information blocking, but left it up to HHS to then create some exceptions. So then calendar year 2017 was the first calendar year that the MACRA information blocking attestations under meaningful use went into effect. So anyone reporting for calendar year 2017 was at that point required to attest that they were not information blocking. Then fast forward a few more years, March 2019, we got a proposed rule under the Cures Act by ONC with respect to information blocking. And then April 2020, right when we were all somewhat otherwise occupied, but we had OIG issued a proposed enforcement rule with respect to its piece of information blocking enforcement with respect to some actors, but not others, and I'll come back to that. And then we had, in May of 2020, finalized, it actually was kind of pre-released in March, but we got the final version May of 2020 of the final Cures Act rule by ONC. And then that originally called for enforcement, well, for the applicability date, kind of the compliance date, to be November 2nd. And it was talked about for months, but finally actually happened at the end of October and was officially published in November 2020, a extension of the enforcement date till April 5th. And that's kind of where we are today. So what's missing? Well, we have a proposed enforcement rule from OIG, but we don't yet have a final enforcement rule. And we don't yet even have a proposed enforcement rule from HHS with respect to healthcare providers, let alone a final enforcement rule. So we still have a number of things to come. So we have this puzzle where we've got two different information blocking standards at play here. So we've got MACRA, and with respect to MACRA, there's essentially 3 attestations as part of the Promoting Interoperability program performance criteria under meaningful use. And so this should not be new if you are a healthcare provider participating in the meaningful use program. It's been in effect, as I noted earlier, since the calendar year 2017 reporting period. So no big change there, other than in a companion regulation to the ONC rule that was published in May of 2020, we got a CMS rule that indicates that at some point in the near future, attestations will be publicized on CMS that if you are not attesting that you are information blocking, apologize for the double negative, but if you do not attest that you are not information blocking, then you will be listed on the CMS website as failing to have attested that you are not doing information blocking. So do I think that patients are going to choose their healthcare providers by going onto the CMS website and checking whether someone has attested to not information blocking? No, I don't think that this is going to be a huge stick, but it's a little something. But then we've got the Cures Act, and there we've got a new definition of information blocking and a broader set of, quote, actors and different penalties than what you have under MACRA, because MACRA only really affects the healthcare providers that are participating in the meaningful use program. It's not going to affect, say, your Beverly Hills cosmetic surgeon who is not getting paid by Medicare or Medicaid for his or her services, whereas the Cures Act, broader set. So MACRA, information blocking, what are those 3 attestations? Well, to kind of paraphrase them a bit, the first one is that you did not take action to limit or restrict the compatibility or interoperability of certified EHR technology. So you've purchased the EHR technology, probably back in 2010, 2009, 2011, something like that. You have updated it throughout the years based on the latest versions. Currently, we're at kind of the 2015 certified EHR technology. But you do have all these nice little configurations that you can control on your end. This first attestation is essentially that you're not tweaking those to try to minimize sharing of information or interoperability, to make it essentially more difficult for information to flow outside of your EHR. So then the second attestation is essentially that you have implemented the certified EHR technology so that it's connected, compliant with applicable standards, and allow those patient access and bidirectional exchange with unaffiliated healthcare providers. So in other words, you do need to have an internet connection here. You do need to have your EHR connected up so that information is able to flow to other EHR systems and patients, for example. So then the third one is that you have responded in good faith to requests to exchange electronic health information. So let's go back to that little email use case that I included at the beginning. Pressing delete multiple times and completely ignoring that request is not just potentially information blocking under the 21st Century Cures Act, but it actually could be information blocking arguably today under MACRA, and could lead to that you need to attest that you are, in this case, that you wouldn't be able to attest that you are not information blocking. Or alternatively, if you do attest that you're not information blocking, but you ignore that the good faith request, you could find yourself subject to False Claims Act liability. So that's MACRA. That's in place today, has been in place for a few years. And that's really all I'm going to say about MACRA. Now I'm going to really turn to the 21st Century Cures Act, the one that's causing everyone to pull out their hair right now, and focus on that one instead. So let's talk about the elements of information blocking under the 21st Century Cures Act. So oddly enough, the statute starts off with exceptions. Usually I have exceptions coming at the end, but they went ahead and put it at the beginning. So if the practice is required by law, then that is going to be an exception. So you are not going to have conflicts with state law. I get this question a lot. Well, what happens if state law says X? Am I information blocking? No. So I've got some clients in Oregon. There's a state law in Oregon for labs there that says that if a patient goes to the lab and requests a copy of lab results directly from the lab generally has to delay release of the results for 7 days unless the ordering physician has specifically instructed or authorized the lab to release results directly to the patient. So, complying with that Oregon law would not be information blocking because the practice is required by law. Now, the other exception falls under an HHS rulemaking exception. So the statute said, HHS, you go ahead and create these exceptions for what are kind of reasonable activities that are not information blocking. And so HHS, in the May 2020 information blocking rule, that's much of what the rule consists of, is those exceptions. And we'll come back to those exceptions. And my word processing team, I had them adjust this to our template, and I think they messed up on the indentation, on the indenting. The practice is likely to, that is not an exception. That starts getting into the actual elements here. So if you don't fall under one of those exceptions, then the elements are, is the practice likely to interfere with, prevent, or materially discourage? So prevent or materially discourage, the regulation treats it as kind of subsets of interfere. So really, do you have a practice that is likely to, so not a theoretical possibility, we're talking that it's essentially more likely than not that the practice will interfere with, including preventing or materially discouraging, access, exchange, or use. Those three words are pretty key words for information blocking. You're going to be hearing me say them a lot. And access, exchange, or use of what? Electronic health information. So if your practice is likely to interfere with access, exchange, or use of EHI, electronic health information, and it doesn't fall under the information blocking exceptions, including that it's not required by law, then you potentially have information blocking. But there is a knowledge component, and this one gets lost in the shuffle quite a bit and is really key. So if you are a health information technology developer, health information exchange, or a health information network, then the knowledge standard is that you knew or should have known that your practice is likely to interfere with access, exchange, or use of EHI. But if you're a healthcare provider, the knowledge standard is that you knew the practice to be unreasonable. So if you meet all the other elements, but you do not know that your practice is unreasonable, if, for example, you believe your practice to be reasonable and you're a healthcare provider, then that is not information blocking. And this is going to be an interesting one from an enforcement perspective. So for healthcare providers, whatever regulator ultimately becomes the regulator for healthcare providers, we don't know whether that's going to be ONC, CMS, OIG, although that seems a bit strange under the statute because it says OIG, you should refer healthcare providers. Wouldn't make sense to kind of refer back to yourself. Could be OCR with respect to their enforcement of the privacy rule. They might be a good fit. So we don't know which regulator within HHS is going to be the enforcement body with respect to information blocking for healthcare providers, but they will have quite the challenge that they have to actually demonstrate that the healthcare provider knew the practice was unreasonable. So who is subject to information blocking? We've got 3 categories of actors. So first is healthcare providers. Second is health IT developers, a certified health IT. And the third, it's actually 2 categories I kind of got just lumped together: health information networks and health information exchanges. So healthcare providers, your usual suspects: hospitals, skilled nursing facilities, group practices, labs, pharmacies, exactly who you'd expect to be a healthcare provider. So health information networks, health information exchanges, this one's a bit more interesting. So certainly the ones that you'd expect. So things like, your state health information exchange, for example. But the language is drafted that it's essentially anyone who controls or has discretion to administer, permit, enable, or require the use of any technology or services for access, exchange, or use of EHI among more than 2 unaffiliated individuals or entities. So it has to be at least 3. And the exchange is for treatment, payment, or healthcare operations. So for example, I was part of the Digital Bridge program that looked at health information exchange for purposes of public health. So if an exchange is strictly for purposes of public health, that would not fall under here. But if you are essentially in a position to enable or somehow control the exchange of essentially 3 or more unaffiliated individuals or entities, their exchange of EHI for treatment, payment, or healthcare operations, as those terms are defined under HIPAA, then you are a health information exchange or health information network. So let's go back to the example I mentioned earlier and explain what was probably a little bit unclear at the time. So let's say you're a hospital and you have an EHR system, not only for yourself, but through what's sometimes referred to as an EHR donation program. You are offering your EHR instance to unaffiliated healthcare providers, physician practices in your community that are independent from you. So, I don't mean to pick on one vendor versus another, but the most well-known example of this is Epic has something called Community Connect, where essentially a hospital will have its instance of Epic and then can actually host Epic for physician practices in the community. And so in that case, when the hospital has its own records, it's acting as a healthcare provider. But by hosting Epic Community Connect or some other analogous EHR technology for community providers, if the hospital has an agreement in place, for example, that controls how those community providers are able to share information, then that hospital may actually qualify as a health information network. Let me take an absurd providers, and in this agreement says, okay, you are using our instance of our EHR, you are part of our accountable care organization. One of the conditions of this is you can't share with that guy across the street. who's got a competing ACO and is competing for patients, we only want you sharing with, we only want you sharing your EHR through our platform with us and others within our ACO. That would be a case of the hospital essentially acting as a health information exchange and information blocking by essentially telling the physician practices, you may not share with certain others. So I don't expect that to happen too often, but that would be a case of a hospital acting as a HIE or HIN and information blocking. So we also have this other type of actor, a health IT developer of certified health information technology. And so once again, that's going to be the ones you'd expect, your Cerner, your Allscripts, your Epic, your Meditech, but also, once again, may be who you don't expect. So it's an individual or entity that develops or offers health information technology. And so an example of this might be EHR Community Connect program. And at the time it engages in a practice that is subject of an information blocking claim, has one or more health IT modules certified under the ONC Health IT certification program. So you have to be offering certified EHR technology. But if you meet that second prong, then it covers all your health IT as that term is defined, not just certified EHR technology. So let's go back to our hospital. It is offering certified EHR technology to physicians in its area through an EHR donation program. So not only is it potentially acting as a health information exchange, it also may be acting as a health IT developer, certified health IT, even though it's not the one who developed the technology, it's just offering it. And because it is offering certified health IT technology, it meets that second prong, and all health IT that it then offers is going to be subject to information blocking. So let's say it also offers a secure messaging platform outside of its EHR. If that qualifies as health information technology, that could also be subject to information blocking. And so it is potentially broad here. So we already know, though, from a few slides ago, the hospital is subject to information blocking as a healthcare provider. What difference does it make it? It's also subject to information blocking as a health IT developer of certified health IT technology or a health information exchange. The answer is penalties. If it is acting in these other capacities, it is subject to penalties by OIG of up to $1 million of penalty, as opposed to when it's acting in its capacity as a healthcare provider with respect to its own EHI, then it's subject to appropriate disincentives of a nature that we don't even know what that is yet. So now let's move over to what is electronic health information. So EHI is defined very much in line with the HIPAA regulations. So it incorporates the definition of electronic protected health information as defined under HIPAA. So certainly nothing new there. We've all been working with that definition for quite some time. But once again, it's ePHI, it's not all PHI. So that right off the bat excludes any hard copy information. But then it further limits it to ePHI that would be included in a designated record set under HIPAA. And so a designated record set under HIPAA is medical records, billing records, or other records used to make decisions about individuals. So certainly if it's in your EHR system, that's going to be part of the designated record set and therefore part of EHI. If it's in your billing systems, that too. And this last one, the litmus test I like to use is, if the information is wrong, is that going to impact the patient or the plan member? Really patient here, because health plans, you'll notice, were not one of the information blocking actors identified earlier. So, if the answer is nope, if I am O positive, but the information in a particular file says that I'm AB negative, but that's never going to impact me, because in the EHR itself, it says I'm O positive, and it's correct there and all of that, then maybe it's going to impact a quality assessment study that the hospital is doing, but it's not going to actually impact my care as the patient. And that's going to be outside of the designated record set. If, on the other hand, the fact that my blood type is incorrect in this file has any potential to affect decisions about me, then it's part of the designated record set. There is this one tweak from HIPAA in that HIPAA defines a designated record set as records maintained by or for a covered entity, but information blocking is broader than HIPAA covered entities. That Beverly Hills cosmetic surgeon, if he or she does not ever accept insurance, if it's all out-of-pocket payments, they actually might not be subject to HIPAA because they don't conduct any electronic transactions with a health plan, but they would be an information blocking actor. And so even though they may not be a HIPAA covered entity and may not therefore have a designated record set under HIPAA technically, there's a tweak on the EHI definition to say, well, it would still be EHI if it's essentially maintained on their behalf. If you're a health information exchange, which is not a covered entity, similarly, if the information is maintained on your behalf, it's going to be treated as EHI if it would otherwise qualify as a designated record set.
Adam, we have several questions that have popped up here. Let me just read these out to you and give us your thoughts on these. What is the role, if any, of patient consent to sharing data when evaluating how to handle requests that don't originate from the patient, such as in your original example? Can you respond to that?
Sure. So one of the exceptions is the privacy exception, and we'll come to that in a little bit. But essentially, in some cases, patient consent or patient authorization may be required under a privacy law. And in that case, you would be able to satisfy the privacy exception to not disclose where patient consent is required. But other cases, like the example that I included in the beginning, so HIPAA, for example, permits one covered entity, so say a physician practice, to disclose to, in this case, King's Hospital, for certain healthcare operations of the requesting covered entity, so of King's Hospital in my example, for activities that fall under paragraph 1 or paragraph 2 of the definition of healthcare operations, like quality assessment and improvement activities. And as long as each patient has, each covered entity, I should say, has a relationship with the patient. So in my example, King's Hospital gave enough information to identify which patients have a relationship with both the physician practice and King's Hospital. So that disclosure would be allowed without patient consent. And therefore, it could potentially be information blocking to not disclose, even though the patient has not consented in any way, because HIPAA and potentially state law does not necessarily require patient consent there. So I'll come back to that in the privacy exception in a bit more detail, but that's kind of the role. If patient consent is required, it's not going to be information blocking to not disclose without that consent. But if patient consent is optional, then information blocking is implicated.
Thank you. When a document is scanned into the record, does it automatically become EPHI or EHI?
So it depends on the record. I mean, if it is scanned into the electronic medical record, then seemingly that is part of the medical record, part of the designated record set. Now, I'm going to come back on the next slide to talk a bit about the USCDI, the United States Core Data for Interoperability. And so that will play into it a little bit. But apart from the USCDI limitation that I'll come to in a moment, if it's being scanned into your electronic medical record, then seemingly, I think, once again, this is not legal advice. Speak to your own counsel. But I would say that there's seemingly a high risk that it's EHI.
Thank you. And lastly, are health plans expected to become actors in this information blocking universe at some point in the future? They're currently excluded, but that seems to be something of a gap in the design of a data sharing situation as we're anticipate having in the future between plans and providers.
So they say know your audience. And the last time I delivered this presentation was to the Medical Group Management Association, where it was pretty much all healthcare providers. And there here I know I got a bit more of a mixed audience, and there's some health plans potentially on the line. So for the health plans, don't hate me, but I will say, I think it was an oversight by Congress. I standing on my soapbox for a bit, I think that Congress maybe should have included health plans with respect to information blocking as information blocking actors. I mean, it was not really, though, what Congress was focused on. Going back to the stimulus bill and the EHRs, it was really unlocking the EHR data. And so they were really focused on that. And I think it's a somewhat separate issue, with respect to price transparency and things like that. The fact that health plans are oftentimes not sharing PHI. I think there's a strong policy case to be made for including them in information blocking, but it was not the target. I have not heard any rumblings, which I'm not a lobbyist, so that doesn't necessarily mean anything, but I have not heard any rumblings of expanding the information blocking statute to encompass health plans. So unless a health plan also qualifies as a healthcare provider, health information exchange, or health information network, or a developer of certified health IT technology, it's not covered currently, and I don't have much of an expectation that it would be in the near future.
Okay, we have one last question. To be clear, do patients have no right to limit what data elements can be shared with other entities, excluding payers?
So they have a right. They have a right under HIPAA to request limitations on uses and disclosures for treatment payment healthcare operations. And under HIPAA, the covered entity is generally free to decline any one of those requests unless it's a patient paying out of pocket for services and requests that their information not be shared with a health plan for the health plan's payment or healthcare operations purposes. Now, the privacy exception does then include, under information blocking, does include that if you have agreed to a patient request to restrict their information, their use or disclosure of their information, it is not information blocking to follow that. But right now, if I, as a patient, go to a hospital and request a restriction, my expectation is they're going to deny it. And that hospital then will have to look at an information blocking analysis if, even though I asked for them not to disclose, they denied the request and now have a request from someone out, from a third party, for my information. It does lead me to wonder, thinking aloud here, whether healthcare providers are going to want to reconsider their practices with respect to, if they are finding themselves disclosing information in a way that they think the patient may not want. Instead of just always declining requests for restriction, they might actually want to actively promote requests for restrictions. Would you like, your information limited in this fashion? But that's really something that is going to fall on the healthcare provider, because to potentially change their practices right now compared to the current, patient request restriction. 9 times out of 10, it's gonna be denied.
Thank you. We have a few more, but we'll wait a little while and bring those on you in a few moments.
Sure. So last slide talked about what is EHI. Let's talk about what is not. So psychotherapy notes, as that term is defined under HIPAA. So let me spend a moment talking about what psychotherapy notes are not, because it's an area of a lot of confusion. So psychotherapy notes are not any mental health information that is sensitive and the mental health professional may not want the patient to see. Psychotherapy notes are much more discreet than that. So let's say I am receiving mental health therapy services, and I have my hour session with the therapist, and the buzzer goes off. Therapist says, okay, time's up. Thank you, Adam. Looking forward to speak with you next week. And then the therapist goes and, in the old days, it would be maybe takes out the little dictation and says, okay, we left off with Adam, with him talking about his issues with his mother and the fact that he was dropped twice as a child. And I think there may be something there. We should probably come back to that next week. And the therapist takes down those notes, does not put that into the EMR. Those are not for anyone else to see. That's really just for the therapist's own recollection. That's your classic psychotherapy notes. Now, if on the other hand, the therapist puts down in my medical record, diagnosis, I think Adam is suffering from paranoid schizophrenia, that is not psychotherapy notes. Now, the therapist may have a good faith belief that me seeing that and seeing in my medical record a diagnosis of schizophrenia could cause really big emotional harm to me. That doesn't make it psychotherapy notes. And we'll come back to kind of the preventing harm exception. So a lot of mental health professionals out there are always pushing back and pushing for this psychotherapy notes to encompass a lot more, of sensitive mental health information. So it's important to understand how this is limited. Next bullet, information compiled in anticipation of civil, criminal, or administrative actions. Both of these concepts are taken from HIPAA and bases for denying a patient their right to access PHI. And then finally, information that falls outside the designated record set. De-identified information, not going to be subject to information blocking. You can block access to de-identified information till the sun don't shine, not a problem under information blocking. ePHI that's used for internal quality improvement, business analytics, or otherwise not used to make healthcare decisions about the individual. So going back to that litmus test, if the information is wrong and it's not going to have any impact on the individual, might just impact your own business analytics or quality improvement efforts, then that's outside the designated record set. That is outside of EHI. So we do have, though, a further limitation for the first 24 months, which the way it's ended up playing out is through October 6, 2022 is when the full definition of EHI will go into effect. Until that date, so through October 5th, 2022, we have a more limited universe of EHI, the United States Core Data for Interoperability, USCDI, because Lord knows the healthcare industry loves its acronyms. So you've got the USCDI, and this is really intended to be kind of the new standard for data that should be shared readily. And so this is different than the CCDA, for example, and things like that. You'll see the, on the slide, the bullets for what's included. Of note, this is not just structured data. You see their clinical notes are included, but this is definitely not the entire designated record set. Billing information, not included here. Images themselves, not included here. And so this is definitely a smaller universe. So going back to the question that was posed earlier, what if we scan something into the medical record? Well, if you scan information in and that scan includes an image, that image would, so it includes an X-ray, that would fall outside of the USCDI. If it includes that the patient's handwritten notes that were mailed to the physician and scanned in, that's seemingly going to fall outside the USCDI. On the other hand, if you receive via fax, good old-fashioned fax, a copy of clinical notes from another provider, and you scan that into your system, well, there's nothing here that says clinical notes only limited to those that were created by your own system. So seemingly, the scanned clinical notes fall within the USCDI and fall within information blocking. So I think we definitely will have a challenge, and I've had a number of clients raise this question with me. It is challenging because it's going to be unstructured. It's probably not going to be machine readable. And so you may have to go through and individually look at whether you can pull out the USCDI information from that scanned record. And of note, the USCDI will change over time. There's drafts of a new version in the future. And so between now and October 6, 2022, this, what you see on this slide may change. So let's talk about the biggest misconception out there. When the information blocking rule first came out in March on pre-display and then May officially published, well, everyone was focused on the pandemic. But then came the summer, people started to get a handle on, the new normal of the pandemic, and people started turning their attention to information blocking. And that's when people really went crazy. Okay, so you're telling me that I need to have all EHI pushed out to the portal, including sensitive records, including minors. And that's when people got really, really frazzled. This idea of having to push all this information. I'd get questions like, well, does this include records, historic records? So we've got records from 20 years ago. The doctors are no longer even with our hospital. Do we need to now proactively post that information to the patient portal? And the answer is, well, historic records are subject to information blocking. There's no, EHI is not limited to only new records. But do you have to actually push things out to the patient portal? So going back to a few slides, we saw information blocking is a prohibition. Thou shall not interfere with information, with access, exchange, or use. It is not a thou shall. It is not a thou shall actively push out information. And this contrasts with meaningful use, for example, where meaningful use requires pushing out specific information through things like view, download, transmit, so that a patient has instant access to certain things. And you have to meet certain thresholds for how many patients you are pushing out their information. Information blocking doesn't say that. And so you start getting a bit of a split. You got some people, I know a lot of CIOs out there, everyone looking at the EHR discussion boards, we're viewing it as we need to actively pushing out everything. Lab results, as soon as we get them, need to be pushed out in real time, all of that. And then I started seeing, I came to the conclusion, well, it actually doesn't really say that. That's what I was first thinking, but it actually doesn't say that. And I started hearing other health lawyers who were taking a similar position, but it was a bit of a minority position. And so myself and a number of others reached out to ONC and raised this question. Is it a proactive requirement? That's what a lot of people think it is, but that's not necessarily what it says. And we'd propose that it's not a proactive requirement. And I'm not sure that ONC was entirely certain of this at first. I think I heard at one point they were talking about, well, if you have a patient portal, we expect to use it, but we're not expecting people to go out and purchase a patient portal. And so maybe a little bit of a mix. But ultimately, on January 15th, they published guidance confirming that it is not a proactive requirement. So what they said is, do the information blocking restrictions, regulations, I should say, I apologize, I think I mistyped this, require actors to proactively make EHI available through, quote, patient portals, APIs, or other health information technology? And the answer, I always love it when they start with just one word, no, period. So there is no requirement under the information blocking regulations to proactively make available any EHI to patients or others who have not requested the EHI. We note, however, that a delay in the release of availability of EHI in response to a request for legally permissible access, exchange, or use of EHI may be an information blocking may be an interference under the information blocking regulations. If the delay were to constitute an interference under the information blocking regulations, an actor's practice or actions may still satisfy the conditions of an exception under the information blocking regulations. So this completely turned on its head how I think a whole lot of people are looking at information blocking. I got this, press sent to, we have an information blocking toolkit that a number of people have purchased, and I immediately pressed send to send it to every user of our information blocking toolkit, sent this out and got back responses going, wow, this is the exact opposite of everything I'm seeing on the EHR discussion boards and things like that. I mean, people did not believe this when they saw it. So that really changes the analysis a lot. And I'll come back to culture in a little bit because it also, I think, has a big impact on kind of some of the culture here. Now, does that mean it's a bad thing to proactively push EHI out onto the patient portal? Absolutely not. That's the direction the federal government wants us to go. That is still a very good thing. It's just not required by information blocking where there's not a request. So, Denny, we're going to say something?
Yeah, we have a couple of other questions here. I just want to keep up. One of our guests asked, could you give another example of a psychotherapy note? I get a lot of pushback from behavioral health providers. They want to exempt every note due to either harm or privacy.
So another good example doesn't come to mind, but I'll give you some additional background. So there's, in the commentary that of the HIPAA privacy rule that talked about psychotherapy notes, it talks about progress notes and process notes. And that process notes was the concept that they were pulling from for these psychotherapy notes. And that not everyone has process notes. It's only some that even maintain process notes. And that these process notes, are notes that were really not intended to make it into the medical record versus progress notes that may include sensitive information, those make it in. So, first off, if what might be called process notes are kept, and they have to relate to a individual or group mental health counseling session. So they need to be attached to a counseling session, essentially. So they have to be kept separate from the electronic medical record. If they're certainly kept entirely outside the electronic medical record, and they're kind of these process notes for a therapy session, then you're good. If they are in the electronic medical record, but they're kind of kept separate in some way, like they are siloed in a certain way, it's a little bit more fuzzy, but I think you can still argue that those are psychotherapy notes, but they really need to be kept very separate within the medical record. I mean, these are not just the things that are part of the clinical notes. This is something entirely different. So, that's the best guidance, and I'm happy if that person wants to follow up with me afterwards and shoot me an email. I can readily send you the commentary that describes what psychotherapy notes are. That may prove helpful on that front.
We have, are there any limits or requirements around format or the way a request is fulfilled?
Yes, so there is a content and manner exception that provides for when you do not provide the information in the manner requested, which by its very nature suggests that unless you fall under that exception, there is an expectation that you'll provide the information in the manner requested. And with respect to patients and their personal representatives, this is really no different than HIPAA. Under HIPAA, a patient has always been able to request in the form and format that they would like, and if that form and format is readily producible, you must provide it in that form and format. If not, there's kind of a default that goes into play there under HIPAA. So information blocking is really no different than that. Now, instead of form and format, it's the manner requested. Now, if it is a third party, on the other hand, so King's Hospital in that case said, please provide it in a particular form and format, you had no obligations under HIPAA to provide it in the requested form and format. Under information blocking, now, if King's Hospital in that example said, I want it as a Excel spreadsheet, then if that, you would have to provide it to them unless A, you think it's unreasonable, and we're going to come back to that in a bit, or B, you fall under the concept and manner exception, in which, for example, it's technically infeasible, and then that exception includes this, whole order of preference for, okay, well, if you can't do it that way, then do it this way, and if you can't do it this way, then do it this other way. So we'll come back to that concept and manner exception in a bit. You're on mute, Denny.
Thank you. There was a car honking in the background, and I didn't want to exchange that with the rest of the group. A couple of other questions regarding programs that might be affected by information blocking. One is, if a hospital chooses not to share direct addresses for a CCD exchange with a competitor, does this constitute information blocking? And the second one is, do care management programs from a payer run into information blocking or comparable privacy related rules?
So I'll take the second one first, which is, I think it's actually the exact opposite. The care management program from the health plan is not subject to information blocking, assuming that the health plan is not also a healthcare provider, health information exchange / network, or health IT developer. But it does get the benefit of information blocking. So if the health plan, as part of its care management, is reaching out to a healthcare provider and saying, I would like certain PHI, in the past, the healthcare provider can say, yeah, no, thank you. Now, denying that request could potentially be information blocking. So it's not that the health plan is potentially penalized under information blocking, but rather could be the beneficiary of information blocking. Now, direct addresses, if you are essentially getting a request for EHI, once again, educational guidance, not individualized legal advice, but one would think that if a healthcare provider is getting a request to exchange EHI through direct messaging and is withholding the information that would allow that to happen, so either not providing their direct messaging address or providing it but not exchanging trust certificates or whatever with respect to direct messaging, that would seem like a practice that interferes with access, use, or in this case, exchange of EHI, and therefore potentially information blocking. Now, going back to the knowledge standpoint, the provider would have to know that its practice is unreasonable, but withholding your direct messaging address, it would be, I would say a regulator would have a pretty strong case that you knew your practice to be unreasonable, unless you have a really compelling reason for why you're doing that.
Okay, thank you.
Okay, so let's talk a bit about penalties. So I alluded to them before. We got $1 million penalty for violations by health IT developers of certified health IT, health information exchanges, and health information networks, including potentially hospitals or other healthcare providers to the extent that they are acting as those actors. Versus if they're acting as a healthcare provider, then we just have appropriate disincentives that fall under existing authority. So they're not supposed to come up with anything new. They're supposed to use existing levers to do appropriate disincentives. And we're awaiting rulemaking, and I am scratching my head. I honestly don't know what existing authority gets to all healthcare providers out there. I mean, there's a whole lot of existing authority that can get to some healthcare providers. So you could certainly ding meaningful use payments. That would be using existing authority to create an appropriate disincentive for information blocking. It's somewhat duplicative of what we already have under MACRA, but certainly that could be an appropriate disincentive. But there's a whole lot of healthcare providers that are not participating in the meaningful use program. So it doesn't seem to really be an effective disincentive for them. Well, what about conditions of participation? Maybe kind of the nuclear option, a hospital or a physician is violating conditions of participation or their supplier agreement or something like that if they are information blocking, and therefore they're no longer able to receive any Medicare reimbursement or maybe some analogous Medicaid reimbursement. Well, that can get to a whole lot more. That's going to cover a lot of healthcare providers who are not participating in the meaningful use program. But that darn Beverly Hills cosmetic surgeon who's paying for everything out of, everything is paid for out of pocket, not billing insurance at all. Not sure how you're getting to them. So I don't know what existing authority we might have that would get to that Beverly Hills cosmetic surgeon, for example. So we'll be interested to see what those appropriate disincentives are. Where we've left off at this point is the proposed rule included a request for information, and the final ONC rule said, yep, we received some responses, but that's where we've left off. We do not yet have a proposed rule, let alone a final rule with respect to enforcement of healthcare providers. So compliance date, or as they call it, the applicability date under the information blocking, under the Cures Act is April 5th, 2021. The enforcement date, I don't know. So OIG in its proposed rule said that it is not going to enforce, or it proposes to not enforce with respect to conduct until 60 days after the later of the ONC final rule, which we now know that date was May of 2020, May of 2021, or the OIG final rule. So what that really means is if we were to get an OIG final rule today, we would have 60 days, which would go past that April 5th, 2021 date, before conduct would be subject to enforcement by OIG. If, on the other hand, OIG doesn't finalize its rule until, say, January 1st, 2022, then that means health IT developers, health information exchanges, HINs, health information networks, between April 5th, 2021 and, say, roughly March 1st, 2022, their conduct, essentially the information blocking rule is applicable, but their conduct is not going to be subject to enforcement actions. So that's what we've been told so far with respect to health HIT developers, HIEs, and HINs. Healthcare providers, we don't have a proposed enforcement rule yet. My guess is that when we do get an enforcement rule, it's going to probably follow the OIG with respect to not enforcing it until conduct 60 days after the enforcement rule is finalized. But we don't know that with certainty. So it is certainly possible that we could have a proposed healthcare provider enforcement rule December 1st, 2021. We could have a final healthcare provider enforcement rule October 1st, 2022. And that then whoever ultimately enforces against healthcare providers could go back all the way back to April 5th, 2021 with respect to information blocking conduct. It's possible, it seems unlikely. It seems much more likely that they'll follow what the OIG has done here. So really big question marks. Is it possible that if you information block as a healthcare provider on April 6, 2021, that there will be penalties down the line? Yes, possible, but probably unlikely. That being said, the macro attestations continue. So you still should not be information blocking under the macro standards. So now let's talk about exceptions. So we have 8 exceptions that were promulgated under the regulations. 5 of them in the upper half relate to failing to essentially fulfill a request for access, exchange, or use of EHI. The bottom 3 is you fulfill it, but in a way that might be somewhat problematic and could qualify as interfering. So ONC kind of created this dividing, and the regulations reflect, you've got essentially 45 CFR Part 171. The 100s relate to kind of the core elements. The 200s relate to these top 5 exceptions, and then the 300s relate to these bottom 3 exceptions. And so it's kind of divided out in the regulations this way. So A practice that does not meet all the conditions of an exception is not automatically information blocking. And here, especially if you are a healthcare provider, if you don't fall under an exception, it's still not information blocking unless you knew the practice to be unreasonable. And so we'll come back with preventing harm, for example, as a place that a whole lot of people have been very worried about. And you really have to keep in mind that just because you don't fall under the exception does not mean you're information blocking. But if you don't fall under exception, you're not kind of safe harbored. And so a regulator will look at your practice. And if you're a healthcare provider, we'll look at whether you knew the practice to be unreasonable and could potentially second guess you on your determination of what was reasonable. So it's going to be a very facts and circumstances specific inquiry. So first exception, preventing harm exception. So I've used these same slides, sometimes done in 45 minutes, sometimes 2 hours. I have not included all the details, of these exceptions. I'll talk about them a bit more in detail than I would if I was doing this in 45 minutes. But all of these are very complex and include a lot more than what's on the slides. So preventing harm exception. This is about protecting patients and other persons against unreasonable risks of harm that could justify a practice that interferes with access, exchange, or use of EHI. So this exception includes 5 different conditions to it, and you have to satisfy each one of those 5 conditions. Things like it has to be a reasonable basis. It has to be a nature of harm either on an individualized basis, like not we are enacting this policy with respect to all patients that we're going to delay all Huntington's testing results for 5 days. That's not individualized versus for Adam Green, in his particular case, we're going to delay it for 5 days. That would be an individualized determination. It always has to be this individualized determination, the one exception being if you believe that information is in error. So if you get a whole bunch of data and you believe it's been corrupted, then you don't need to do an individualized determination. You could have a more broad determination to block that information to avoid harm. The type of harm, it has to generally be life or physical safety of a person. That could be the patient, that could be someone else. There's the classic case of, if you disclose the information to the patient, you're worried that the patient's going to go out and hurt someone else. And so you deny them access to their information. That would fall, even though that the potential harm there is not to the patient, but to someone else. In general, though, emotional harm is not going to cut it under this exception. So there is a lower standard of substantial harm, and that could include emotional harm, at least substantial emotional harm, but that's only available in really 2 circumstances. One, the requester is not the patient. The requester is a personal representative, and providing the requested information to the personal representative, the parent, for example, would cause, there's a reasonable belief that it would cause substantial harm, including substantial emotional harm to the patient, the child, for example. The other exception for this lower standard of substantial harm would be if the information references someone other than the patient and other than healthcare providers. So let's say Denny and I are in a group therapy session together, and there's information in my record that, if it was disclosed, could cause substantial emotional harm to Denny based on that information getting out. That would be an example where, yes, even if it's not going to cause endangerment of life or physical safety of anyone, the substantial emotional harm to Denny would be a basis to deny access. So those are the limited circumstances, very, very limited, where substantial harm is the standard. For everything else, it really needs to be life or physical safety of someone. And there must be a reasonable belief really by the clinician, by the a treating provider, that the practice will substantially reduce that risk of harm. So this was one that caused a lot of heartburn for people. Are you telling me that now I need to instantly push out lab results without having an opportunity to talk to the patient? I think that's going to cause a lot of emotional harm. And a whole lot of physicians culturally were not very keen on this idea. Well, we've learned a few things. So first, you're not required to proactively push things out. So this is only triggered if someone actually requests the EHI. And then if you're a healthcare provider, it's not going to fall under the preventing harm for you to have a policy, for example, to delay results of a certain, HIV tests, Huntington's disease, various other sensitive conditions. If you have a policy that says we're going to delay release for 5 days so that the physician has an opportunity to talk to the patient, that is not going to fall under the preventing harm exception. Because maybe there's a few instances where doing so will prevent physical harm, but it would have to be an individualized determination. Kind of an across-the-board policy is not going to cut it under the preventing harm exception. But what gets lost a lot of the time is that's not the end of the story. The fact that it doesn't fall into the preventing harm exception, if you're a healthcare provider and you've got that policy is only information blocking if you know that policy to be unreasonable. So if you think your policy of waiting 5 days is reasonable, not going to fall under the preventing harm exception, but the regulator would have to prove that you knew the practice to be unreasonable. Now, if you delay it for 59 days, that I think you have a much harder time showing that that's reasonable. But some of these policies that we have existing that don't fall under the preventing harm exception, there may be a good basis to say, well, we believe they're reasonable and therefore they're not information blocking. So that's the preventing harm exception. It also includes a condition with respect to certain written policies. So I would say on this one in particular, but all the exceptions, make sure and go and look at, if you try to fall under the exception and look at all of the conditions that have to be met. I can't get to all of them on a presentation like this. Denny, you're on mute. Go ahead.
I'm practicing. I'm getting better at this. Does information blocking apply to providers who are seeking information about progress after discharge from direct services?
So does information blocking apply to a provider who is seeking information?
Maybe about a patient in post-acute care, for example, after discharge from the hospital.
So similar to the health plan, they're going to be the beneficiary of information blocking here. So in seeking information, they are not engaged in a practice of interfering with access, exchange, or use. But the provider who has the information may have a greater obligation under information blocking than they did in the past to provide the requester with the information. And so that healthcare provider may be a beneficiary of the information blocking rule in seeking that information.
Thank you. Do we expect all cases of info blocking to be initiated by a complaint, or is there any proactive surveillance look at practices around information blocking?
So I have not heard of any, and I find it fairly unlikely. We don't, once again, know which regulator it's going to be. So ONC, CMS, OCR. But none of them have too much time on their hands, to my knowledge. And I used to work at OCR. And so I don't expect there to be much proactive information blocking auditing going on out there. I really do expect it to be complaint driven.
Great, thank you. And lastly, it is not uncommon that practices inactivate patient registrations after a period of time or a known geographic relocation. How would data blocking inform this practice or instruct this practice?
So patient registrations, meaning the information that they have about a registered person.
I would assume it's demographics and information specific to a patient that isn't related to a visit.
If it is EHI, which seemingly, if it's basic demographic information about a patient, it would be, and someone requests that information, then the fact that it's been, it's once again, it's not a proactive requirement, so you don't have to proactively push this stuff out to a patient portal. But if someone is requesting that information, then the fact that the patient has moved or been inactive for some period of time is not a basis in itself for you to deny access to that information. Now, I don't know of any exception that is going to cover that, but you do still have that reasonableness. If there's some reasonable reason to be withholding that information, that could be then it would not be information blocking.
All right, thank you.
Okay. So the next exception is the privacy exception. So this one has a few different permissions in there. It's not like the preventing harm one where it's 5 different conditions that have to be met. Instead, this has kind of what's called sub-exceptions. And so if you meet any of the sub-exceptions, they may apply. So you may comply with a patient's privacy request. So getting back to that earlier question that we received, if a patient requests a restriction on the use or disclosure of their information, and you agree to that, you are permitted to comply with that, and that would fall under the privacy exception if there are certain criteria that you'd still have to meet there. So also, you must comply with privacy law requirements still. And this arguably also falls under the required by law exception more generally. So random person knocks on your door and says, hey, give me all your patient information. You'd be violating probably multiple privacy laws if you just handed it over. Now, if they came to you and said, I've got this authorization, and that authorization complies with all relevant applicable privacy laws, then you can't use privacy law as a defense, and you'd have to provide the information. But most times, the crazy stuff is not going to be allowed under privacy laws, and it's going to fall under this exception. So if a privacy law permits disclosure, then you must disclose, though, unless another exception applies, including potentially taking the position that the interference is reasonable. So big picture, the way to think about this, and I mentioned culture because this is a big cultural shift here. So we have the Hippocratic Oath, which dates back centuries, if not millennia, and essentially says you will maintain, you as a healthcare provider, or you specifically as a healthcare professional, will maintain the confidentiality of a patient's information. And this really kind of shifts that and changes it to the other direction. It says, yeah, you will disclose your patient's information unless a privacy exception applies. And so that's quite the cultural shift. And trying to explain that to physicians, is not as easy as just a policy or training. I mean, this could represent, something that's going to occur over a long period of time too. We're still fighting battles under HIPAA with physicians not wanting to share information that under HIPAA since 2003 has been required to be shared. And I think we're going to have those same battles with respect to information blocking. So the way I would think about privacy is kind of 3 buckets. So you have you must. So you must provide protected health information to a patient or a personal representative where they're requested, or to HHS, or there might be some other law, like a gunshot reporting law that requires a disclosure of PHI. So under privacy laws, you've got all these required disclosures, either required under the privacy law or permitted under the privacy law and required under some other law. All that remains unchanged. If you had to do it before, you still have to do it under information blocking. Second big bucket is thou shalt not. So privacy laws that prohibit you from disclosing. So without a patient authorization, a whole lot of stuff you shall not disclose. All that remains unchanged. Essentially, if you are not required to do it under a privacy law, it can fit under the privacy exception. You want to cross your T's, dot your I's with respect to making sure you've met all the criteria of that exception, but ultimately, complying with the privacy law, you're going to be fine. Then there's this third bucket under the privacy law, discretionary. All these different disclosures that the privacy law permitted but did not require. And that was the HIPAA privacy rule has dozens and dozens of different permissions that fall under this category. And that's where information blocking really plays. So in the past, if it was discretionary, whether it be someone provided you a request with an authorization, or whether the request did not require an authorization, like a quality assessment study from another covered entity, you have the choice of saying, yes, I will go ahead and disclose that information to you, or no, I don't feel like it. And now the no, I don't feel like it is potentially information blocking. So that's how information blocking really interplays with privacy. So next we've got the security exception. So let's talk about what this is and what this is not. So you are allowed to have practices that interfere with access, exchange, or use as necessary to protect the security of information. Has to be somewhat targeted, has to meet, it should meet industry standards. And so creating a password requirement for people to be able to access their PHI, or in this case, their EHI, that seemingly valid security, you should be fine. Making it a minimum requirement of 100 characters, probably not going to fall within the security exception because it doesn't kind of fit with normal security standards, that sort of thing. Now, the security exception is really focused on security risks to you. And I think that arguably includes level of authentication. I mean, if wesellyourdata.com comes to me as a healthcare provider and says, oh, Adam Green has requested his information through our app, take her word for it. Now, I think reasonable security might be finding out how you know that it really is Adam Green and not a hacker or someone like that who is requesting the information through your app. So I think that is arguably valid security. Now, on the other hand, if they've got valid authentication, like we are, sellmydata.com is using your API and is able to show that they've got Adam Green's credentials, which indicates that Adam Green, has provided the credentials to your patient portal and is looking to access the data through wesellyourdata.com. So that would, the fact that wesellyourdata.com may have horrible privacy and horrible security, that is not a basis to deny access. So, if they're looking to have you transmitted in an insecure fashion, that's a valid security concern. But the fact that they may have terrible security on their end, no, the ONC is pretty clear that that is not a basis for you to deny access. And that's something that I think is going to be closely scrutinized. Now, you can educate the patient and say, there's something about that wesellyourdata.com. I'm not sure what it is, but something's just setting me off there. And you may want to think twice about using that. That education is perfectly fine. But if the patient comes back and says, they may not have good security and they may be selling my data, but for every dollar that they make, they give me 5 cents. That's good enough for me. Then you have to go ahead and disclose the information. It's probably going to be treated as information blocking if you kind of paternalistically say, nope, won't do it. And while you could claim reasonableness, that you didn't know the practice to be unreasonable, that one I think is going to be pretty closely scrutinized if you are essentially second guessing the patient in that sort of circumstance. So that's a bit about security and what it does and does not permit. So there's an exception for health IT performance. And so that would be, you take your patient portal down for an hour from 2 a.m. to 3 a.m. on Sunday. Is that interfering with access to EHI? You bet it is. But that's going to fall under an exception. You're going, that should be fine. You want to look at all the criteria. So for our friends, we take our portal down, we take the API down 1 a.m. to 2 a.m. on Sundays. For enemies, we take it down 8 a.m. to 5 p.m. Mondays through Fridays. That would be information blocking, and that they make clear that would not fall under the exception. But if you're kind of using this in a non-discriminatory manner, necessary, then you should be essentially fine with respect to this exception. So next exception would be an infeasibility exception. You are not expected to do magic. You can point to the circumstances where it is infeasible. So that could be technological capabilities. Someone comes to you and say, I want my EHI and I want it in WordPerfect for DOS 2.0. I'm sorry, we don't have that technical capability anymore. We lost that back in '86. But we can offer it to you in this other manner. That would be kind of technical infeasibility. It's also going to fit into the content and manner exception, which I'll come back to. You might not have the legal right to disclose the information. I would be careful about agreeing to any legal restrictions, but there could be that. There could be uncontrollable events, like, I don't know, say a pandemic back in March of 2020, and you are, in a state of emergency. There might be a basis where it's infeasible to respond as requested. That being said, to fall under the exception, you must provide a written response within 10 business days with the reasons that the request is infeasible. So there's the content and manner exception. So you're able to fulfill the request, but not in the content and manner requested. So with respect to content, that really is focused on, are they asking for a lot more than EHI? Then you're allowed to limit it to EHI. With respect to manner, that's really focused on, okay, this is a bit of Burger King, we do it your way, if we have the technical feasibility to do so. But if you are technically unable to fulfill the request in the manner requested, or if you cannot reach agreeable terms with the requester, my interpretation is that's more focused on licensing. Like, yes, to give you access, I need to license this technology, but we're not able to agree on terms. Then there's this whole concept of, if you can't do it in the manner requested, there's kind of an order of preference. First being, well, can you do it in a standard under certified EHR technology, like a CCDA or something like that falls within the standards for certified EHR technology? So if so, that's your default. If not, the next one would be, can you do it in something that meets either guidance by a federal government or a standard by a recognized standard setting organization by ANSI? If so, that's going to be your next order. If not, can you do it in machine readable format? But absolutely, the last case would be non-machine readable, graphical PDF, for example, that is not, going to help interoperability at all. That is absolutely your last resort with respect to the manner. If it is all possible to do it in one of the preferred formats, you would have to do so. So the next exception is a fees exception. You are allowed to charge fees for access, exchange, or use of EHI. The fees must be cost-based, can include a bit of a profit margin. We don't know what that profit margin is. We don't know if it's that 2% or Apple iPhone 80% profit margin. We don't know what the profit margin, what is a permissible profit margin, but they do say you can have a bit of profit, but it should be cost-based and should be non-discriminatory. Our friends within the ACO or that have done some sort of affiliation with us, they get it for free. Our competitors, they have to pay. That would be problematic. There's been questions about, can I charge a state fee schedule? And we haven't gotten guidance on that, but I think the direction is ONC is likely to say yes, that's probably fine, but we're awaiting guidance on that. So that remains to be seen. Now, keep in mind, under HIPAA, you still, if the request is coming from the patient or the patient's personal rep, then in general, you are limited to a reasonable cost-based amount, and you cannot include a profit margin. It's really only when you're getting requests from someone other than a patient or a personal representative, or if it's a request from a patient to have you send it to a third party based on a decision called SciAx Health, they've clarified that's not subject to the HIPAA rate. In those cases where it's not subject to the HIPAA rate, that's when you do have to look at the rate under the information blocking rule. Because if you say, sure, happy to provide it to you, that'll be $1 million, please. Or if you want to, do the, Dr. Evil $1 billion, that would be information blocking. That is clearly intended to discourage the access, exchange, or use of the information. And there's certain categories that will be particularly scrutinized. Electronic access, the kind of automated computer to computer. Charging a fee for that, highly dubious, closely scrutinized. Or fees for exports. So if an individual says, I really haven't been happy with you, I'm going to the physician practice across the street, please provide me all data you have. Charging a fee for kind of an automated export, that would be problematic. Or clinician is leaving your practice, going over to your competitor, charging them a fee for the automated export of their information, that would also be closely scrutinized. So there's also a licensing exception. This is a lot more focused on kind of health IT developers who might be licensing their technology to be able to access the data. They're essentially this exception allows some protections in place so that they're not forced to go open source and just give their technology away. But there are limits. They can't use their licensing as a way to kind of stop sharing of information with competitors or make it overly difficult. And so there's an exception here. So with that, I will move to how to tackle information blocking. Any questions, Denny, before I move on to that? Oh, you're on mute still.
Thank you. Thank you for keeping me up to speed here. We did have one question from Sean Fernandez, who asked about the costs associated with meeting the request. Can you share that with the requester? And from what you've just told us, essentially it depends on who the requester is and the nature of the request, as opposed to a patient or a clinician asking for their information to be made available to them. Costs in that context would be looked at more carefully than
that's exactly right.
With another system, or with a bulk share of data might be viewed as something that requires a little bit of cost sharing on the part of both parties.
Yeah, and first look at HIPAA, look at state laws. Those may dictate your cost before you even get to information blocking. It's only if there's kind of silence on those and you can charge anything you want, or for that matter, if they allow you to charge significantly more. So under these state fees, you could potentially charge hundreds of dollars for something that doesn't actually cost you much. Even if it's allowed under state fee schedule, it's questionable whether that fee would be permissible under information blocking. And certainly, I think it's in everyone's best interest to minimize surprises and have some transparency. Like, yeah, this is going to cost you roughly this amount, because that will help minimize potential information blocking complaints, I would think.
Great, thank you.
So let's talk about how to tackle information blocking. So I've created a little bit of a chart here. First thing you can do, learn about information blocking. Doing that today. Convening relevant stakeholders, and I'm going to go through each of these in a little bit more detail. Determining when you're an actor. And then, my ideal, it's not required, but my ideal would be drafting policies, training on the policies, identifying the practices that might be information blocking, remediating them, assessing your compliance, and improving, creating kind of a continuous cycle of improvement. Is everyone going to do that? Probably not, but that's something that I would suggest as a potential methodology. So learn about information blocking. Congratulations, you're doing that right now. I will say ONC has some great resources. They have some great FAQs that they've also added on that website. So that would be a great place to look. We have this webinar recorded. There's lots of other resources out there. Next one, convene relevant stakeholders. Think about privacy, compliance, legal, your contracting team. Keep in mind, on contracting, I don't think you necessarily have to proactively adjust contracts, but if the other party is requesting an exchange use or access to EHI as part of the contract negotiation, you need to be aware of information blocking then. Health information management. So if you've got a HIM department, they certainly have to be sensitive to information blocking. Your EHR, your patient portal team, your security team, because there's a security exception, you probably want to have them involved. Figure out when you're a health information blocking. So, if this, I took from a physician practice presentation. Are you a healthcare provider? Yes. Are you a health IT developer? Likely no, unless you offer certified EHR to others. If you're a hospital though, if I presented this to hospitals, sometimes the answer is likely yes. Because I know that sometimes they are offering EHRs to others. Same with health information network or health information exchange. And as I alluded to earlier, don't stop with yes, I'm a healthcare provider, because your penalties and the question, the reasonableness standard. The reasonableness standard applies with you're a healthcare provider, but does not apply if you're these other actors. And so it is important to know which hat you're wearing if you potentially qualify as multiple types of actors. So then think about drafting policies. So you can think about having kind of a high-level prohibition on information blocking, but then think about things like who is responsible for managing information blocking? Who drew the short straw, if you will? What are the procedures for reporting potential information blocking practices internally? Are you going to do any auditing of your practices to regularly check that you're not information blocking? And does your left hand know what your right hand is doing with respect to MACRA versus Cures Act? Because if you've got one person in charge of Cures Act information blocking, finding information blocking, and then you've got someone else who's in charge of meaningful use attesting that there's no information blocking, that's not really good communication. So you may want to think about procedures for making sure everyone is coordinating on that front. So think about conducting training. I don't expect everyone to go through this level of training. Just like under HIPAA, I don't expect that you're going to make every nurse a HIPAA expert on every nook and cranny of HIPAA. But I would expect a nurse under HIPAA to be trained on things like maintaining the confidentiality of information and recognizing that if a patient requests access to their information, you don't just say, no, you don't get to see that. You maybe send them over to the HIM department and let the HIM department know the intricacies of when to deny access and that sort of thing. Similarly, on information blocking, they don't need to know all 5 conditions of the preventing harm exception, but it might be enough for a clinician to know that there is a harm basis for a potential exception, and that maybe that gets elevated to a compliance officer, a privacy officer, or someone who's able to then do the full analysis. So who handles requests for EHI? Make sure that the people who are receiving requests are properly trained and know, not to press delete on that email, going back to that first use case. What are the exceptions? That yes, there is a privacy exception. To whom do you internally report information blocking? So, if you think there might be information blocking, immediately tell Adam Green at adamgreen@.com, something like that. So identify your potential information blocking practices. So think about what systems involve requests and or disclosures of EHI. So I alluded to earlier, we created an information blocking toolkit to help practices, to help healthcare providers and other information blocking actors kind of systematically go through and look at their administrative systems, for example. So health information management department, your contracting department, what are kind of the people and process systems that are involved in kind of the exchange or access to EHI. And then there might be a different tracking mechanism for software systems. What are the software interfaces that involve the exchange, access, or use of EHI. So, whether you use kind of our toolkit or whether you come up with something on your own, doesn't matter. Just kind of think about how you're going to systematically reach out and identify all the little nooks and crannies, all the different practices that may be happening within your organization. So, you can certainly think about things like the patient portal, contracting with third parties, that sort of thing. So then for each system, what are the different practices that potentially interfere with access, exchange, or use? And so in our toolkit, we kind of broke it out a bit. So you've got, where am I actually denying access? And we included some examples that you could see here, like denying a patient's request or denying a third party's request that's accompanied by an authorization. And then there might be other circumstances where you delay. So patient requested, I want my lab results immediately through the patient portal, but you are delaying for 5 days. There might be, what about circumstances where you are discouraging? So, okay, I'm going to charge them an arm and a leg, that sort of thing. And so for each system, maybe that for one system, there's no friction points. Everything is completely smooth and you've got no interference practices. Whereas for another system, maybe your patient portal, there's like a dozen different practices. If a clinician checks a box, it stops the clinical records from being available to the patient portal. That's interfering. We want to look at circumstances where a patient requests their access to the patient portal, but because a clinician flags something, it's not going to be available. We need to analyze that. So you may find yourself with some systems with lots and lots of different practices that are potential interference. So then for each practice that raises an issue, do the analysis. So we created an analysis tool. This was actually our biggest headache. It's a very complex process to go through and each one of the conditions, for example. But you can go through that analysis. Does it involve EHI? If not, don't worry about it, at least not under information blocking. Is the practice required by law? It is? Okay, write that down and you should be good. Does at least one of the 8 exceptions apply? And that's where it gets into, meeting all 5 conditions, for example, of a particular condition. Are all of those exceptions criteria met? And if none of the above, don't forget about reasonableness. So you may be at risk of violating information blocking regulations if you have a practice that meets the elements of information blocking and does not meet any of the exceptions. But once again, it's going to be looked at on a case-by-case basis. And so, don't forget about reasonableness. If you're a healthcare provider, you may be able to claim that that your practice is reasonable rather than that you knew your practice to be unreasonable. So next up, remediate any information blocking practices that you find are problematic. So if you can fit it under an exception, if great. If not, maybe document why it doesn't fit with an exception. I like to talk about the lottery contingency plan. If the person that wrote this down, wins the lottery and instantly retires, are you going to have the documentation so that 5 years later you can show this is why we determined that practice was reasonable? That's the mark of a good compliance program, is having that kind of contingencies in place. So before I get into takeaways, that's the operational side, but I'll once again mention culturally, this is a really big cultural shift from the idea of information being both always confidential and something that in general I should not be sharing, and also information being proprietary. This is my information, not yours. It's a cultural shift from the business perspective and from the clinical perspective that this information should essentially run free to the extent that the law permits it to do so. And that is really the new normal, the new default. That's not something that a policy alone is going to instantly change. That's going to require regularly adjusting. Now, it's not quite the cultural change that I think people had in mind at first, where we now have to post all information to the patient portal. It's not quite that cultural shift. There is still, yes, if the clinician thinks it's reasonable to delay something for a few days, we don't have to say, sorry, it doesn't fall into the preventing harm exception, so tough luck, your decades of experience doesn't count for anything. We still can say, well, I think your practice is reasonable. But there are certainly some circumstances where a clinician may be doing a practice that they've been doing for a long time and potentially qualifies as information blocking, and you don't think it's necessarily reasonable. And that's going to require a real cultural shift within the organization. So takeaways, we got a stay of execution back in November until April 5th, but guess what? We're getting pretty close now to April 5th. It's going to be here before you know it. So convene those stakeholders, get everyone involved, identify those systems. You can focus on the worst case ones. Do we have anything that is just blatantly discriminatory? Before you just, rather than instantly boiling the ocean. But ultimately, at the end of the day, look around at all your systems, look at all the potential pain points of EHI flowing, and assess those pain points, and check each practice and remediate where you can. And so with that, I will open it up to any questions, and I've got my contact information also. So Denny, we've got 7 minutes for any remaining questions.
Well, I'll certainly open it up to the audience and ask folks, if you have a question and you'd like to ask that question, please unmute your microphone or have it into the chat box, and we can follow up with Adam in the few minutes we have. Adam, I have a question. The information blocking provisions coming out of the ONC are in some ways sort of interdigitated with the interoperability final rules coming out of CMS. And this change that you referred to, this culture shift, is really quite profound, where what we're seeing as two opposite sides of the negotiating table are now expected to collaborate in the exchange of information at a level that is unprecedented. And at the same time, there are exceptions to what constitutes interoperability for good reasons, as you've pointed out. Do you consider the culture shift, as you've described it, to be the single greatest impediment to advancing this kind of new world of information sharing and getting actors comfortable and accepting of it? Or do you have other concerns that you see on the horizon for this?
So if you asked me that 4 months ago, I think I would have said yes on the cultural shift. But back when it was really telling, where everyone was telling their clinicians, unless you fall into the preventing harm exception, everything needs to be instantaneous. I think the fact that we've now gotten the clarification it's not a proactive requirement makes it a bit less of a cultural shift than we had before. It's still a cultural shift, make no doubt about it, but not quite as daunting as where I think some people were at the beginning of this process. So, in that sense, I think that the bigger issue may still be technology in certain respects. So, healthcare providers, we've had EHRs for now some time, and we've, that's been built out to be somewhat interoperable. And now information blocking is just really helping to make sure that you are fully using that, versus health plans, they were not subject to this. So we now have the companion rule really first making health plans have to open up their records to APIs, but only a small minority of health plans, only those that are involved in certain federally regulated spaces like the health insurance exchange, not the vast majority of private plans. And so, I think we still have huge technological impediments, but the APIs definitely will help alleviate that So I think that impediment's going away in the next few years, or at least being reduced significantly.
We have a question. How does a provider know what the patient is requesting when accessing their patient portal?
So I've had the question of, does the mere fact that they sign up for or log into the patient portal mean that that's a request for all of their EHI and we have to provide it? Reasonable minds may differ on this. My view is no, they could be accessing the patient portal because they want to do a secure message or schedule an appointment. It doesn't necessarily mean that they are requesting their clinical notes through the patient portal. So I think there's a pretty good argument that it requires something more specific, like the patient coming, not just logging into the patient portal, but actually requesting over the phone or some other way that their full EHI or specific EHI, like my clinical notes, be made available through the patient portal. And those are going to be obviously far less than just everyone who logs into the patient portal.
We also have a question that's directed to me, but I think it's for both of us, which is, can you explain again about the various preferred formats for data exchange? You mentioned PDF as a last resort, but what if the practice-specific format of the EHI does not map cleanly onto existing standards?
Well, first off, there's the question of, are you dealing with certified EHR technology? If you are, then the fact that it's been certified means it should have the ability to output in certain respects. And so if the individual comes and asks for WordPerfect for DOS 2.0 and you're not able to output that way, if you're dealing with certified EHR technology, you should be able to output in a CCDA standard format or something like that. So now, and if you're a health plan, well, you're not an actor, so that shouldn't be as much of an issue. So it's really, I think, if you've got EHI that's sitting outside of the certified EHR technology, that's when it becomes more challenging, because obviously it's outside the certified EHR technology. It may not have that same standard-based output. And that's when the next order would be some sort of federally recognized standard or a ANSI, American National Standards Institute, recognized standard. So if you're able to output it that way, then that would be preferred. If not, then I would look at, like a XML or CSV format, some sort of machine readable format, whether that could potentially work would maybe be my next one. And then the very last resort is PDF, graphical, or TIFF that is not in any way machine readable.
And from our vantage point, at least the work that we do at MHDC, the US CDI does specify with fairly broadly, but starting to get increasingly precise about what vocabularies need to be employed for what data elements. So SNOMED is usually the medical nomenclature, LOINC is the laboratory nomenclature, RxNorm is the pharmaceutical nomenclature. Sometimes the US CDI specifies multiple ones, but in all reality, we're likely to converge upon a few standards that address clinical data. And if Jacob, you're interested in learning more, you please email me. We could talk a bit about the code mapping service that we'll be setting up for organizations to help them navigate from living in an ICD CPT world to starting to live in a world where you need to be multilingual, and how to do that electronically. We'd be happy to talk about that in further detail. So we're just at the top of the hour. Adam, I really want to thank you for an absolutely fascinating and informative presentation. This, I'm sure, is as much as any of us could have possibly expected to get about information blocking, probably for some of us more than we wanted to hear in some cases. But I think for generally for everyone, this answered a lot of questions that I had, and I'm sure that a number of our attendees had. So I want to thank you on behalf of our audience and on behalf of the Massachusetts Health Data Consortium for providing us your expertise today. I want to thank those of you who were able to join us today for this discussion. Please make note of Adam's contact information on the slide if you wish to reach out to Adam directly. And we will make the presentation as well as the recording of the webinar available over the course of about the next 72 hours or so. We need a little time to pull that together. So barring any other questions, again, Adam, thank you very much for your insight and your expertise to this. I want to thank everybody else, and we are adjourned.
Thank
Take
you
care.
for having me.